Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here with another update. You guys remember a couple of weeks ago I shared with you all a motion that Steve Greenberg had filed where he was concerned that the Northern District of Illinois had issued subpoenas for some bank records for a company called Some Brothers Love Incorporated that Mr. Kelly set up so that his royalties can be transferred to one of his childhood friends, you know, while he was going through what he's going through. And then they also looked into the bank records of one of his attorneys. I thought the attorney was more than likely Doug Anton. Some other people believe that it's Thomas Farinelli, I think his name is. He's the guy that's handling the New York appeal to get bond, and he's also him and Doug Anton are attorneys on the Faith Rogers case. And then there was another company, an international law firm, I think they said, that they had gone back to 2013 requesting their records. And so the assistant state attorney or assistant United States attorney, Angel Krull, when Steve Greenberg contacted her about this, you know, she was, you know, kind of snippet. And remember, she's the one that said that, you know, she was motivated to bring these charges based on SRK1. And so, you know, she's here with the BS. But anyway, they have responded to that motion. So let's go ahead and get into it. So it says, government's response to Defendant Kelly's motion for disclosure and protective order. The United States of America, through its attorney, John R. Lausch Jr., United States Attorney for the Northern District, Illinois, hereby responds to defendant's motion to require the disclosure of grand jury subpoenas, production of all grand jury materials, and for a protective order. Docket number 133. In the motion, he alleges that the government acted improperly in discussing, hold on a second. In discussing, okay, let me go back here. Okay, improperly in issuing grand jury subpoenas that resulted in the collection of bank records of Kelly's current and former counsel, specifically Attorney A and law firm A. For the reasons identified below, the government respectfully requests that the court deny the motion. So, one, introduction. The superseding indictment alleges that over the course of 20 years, he paid money to others, including one of the people involved in the case family, Darren McDavid, and individuals B, C, and D, in exchange for them to lie about his relationship with this person. And guys, you know I'm talking over. I'm not saying exactly what is being written here. Then it goes on to say he made many of these payments through an attorney. During the course of his investigation, the government issued subpoenas to banks for accounts from which these payments were made and for accounts that received these payments, collecting evidence proving he was paid and that he or his businesses were the source of the payments. In addition, in the course of its investigation, the government identified a bank account that Kelly appeared to control through a nominee third party, in part because of his history of bribing victims and witnesses. Okay, we need to go back, allegedly bribing people. The government investigated this account to determine whether he controlled it and whether he was using a nominee to conceal its activity. To that end, the government issued bank subpoenas relating to various payees from the third-party account whose identities were not known to the government. When the banks produced records in response to the subpoenas, the government learned that 2 of those payees were attorneys, including Attorney A. The government produced to all counsel the records that it received in response to those subpoenas, pursuant to the strict terms of the protective order in the case, docket 53. And let me go back a few minutes, because that might have been confusing when I was reading that last paragraph. Basically, they're talking about the land fairs, and they're trying to trace checks that were written to her or to her family to see if they were coming from these different accounts or any of the other, I guess, payments that were made to people, but mainly the land fair family. It says, Kelly now asserts that in issuing those subpoenas, the government went on an unreasonable, intimidating, and harassing fishing expedition relating to his current and former counsel, specifically Attorney A and law firm A. Not so. As explained below, the government had legitimate law enforcement reasons for subpoenaing the bank records at issue. The bank records proved that the defendant paid $125,000 to individual B for recovering and returning tapes showing him with one of the victims. And so we know that's who, Lisa Van Allen. These records also help prove that defendant controls a nominee bank account that received at least $1.2 million last year, despite claiming to this court that he, quote, has no money. This account was established in early 2019, shortly after he was charged in the case by Cook County. By directing substantial income to a nominee bank account, it appears he was attempting to avoid financial consequences associated with the pending charges in this and other cases, including fines and restitution. Moreover, given his past conduct, there is a risk he would use these funds to continue his pattern of paying off witnesses and victims to lie or remain silent about his crimes. All of these facts made it reasonable to subpoena records related to the accounts at issue. Liking standing to quash the subpoenas at issue, and because such a motion would be moot at this stage anyway, he instead requests that this court order the government to disclose all grand jury subpoenas and materials not previously disclosed. The requested relief is not appropriate. Out of an abundance of caution, the government already sought and received from counsel for McDavid and Brown the return of records related to Attorney A. The government agrees to do the same for bank records related to law firm A. It has already asked for the return of those records from all counsel, will destroy copies of non-relevant materials included in that production, and will produce to counsel only those records it intends to use at trial. The reasonable measures are sufficient to address counsel's concerns. Accordingly, his motion should be denied. Then in part 2, it says the government reasonably subpoenaed records related to payments to individual B. The Supreme Court has long recognized that the grand jury's investigative powers must be broad if its public responsibility is adequately to be discharged. And then they cite a case, Brunsberg versus Hayes, which is a case from 1972. Indeed, a grand jury investigation is not fully carried out until every available clue has been run down and all witnesses examined in every proper way to find if a crime has been committed. Now that's real interesting that they would say that, because they are trying to deny the defense the same courtesy to track down all witnesses and to defend any allegations that a crime has been committed. So come on, y'all. You can't, what's good for the goose is good for the gander, okay? So then it goes on to say, accordingly, the grand jury may compel the production of evidence or the testimony of witnesses as it considers appropriate, so long as compliance with the subpoena would not be unreasonable or oppressive, which, unlike a trial subpoena, need not be tailored to evidence that would be relevant and admissible at trial. And then they cite another case, and it says, in the grand jury context, the decision as to what offense will be charged is routinely not made until after the grand jury has concluded its investigation. One simply cannot know in advance whether information sought during the investigation will be relevant and admissible in a prosecution for a particular offense. So what they're saying here is they just went on a wild goose chase, and then once they gathered all their information, they basically looked at it and said, okay, what charges can we bring based on this information that would give us any iota of a chance at a conviction? So it's not necessarily that the information is concrete, but they've tailored their case around this information, hoping that something that they throw up will eventually stick. So it goes on to say, consistent with the authority, the government used grand jury subpoenas to investigate payments made by and on behalf of him to pay off witnesses and to compensate persons for their efforts to conceal evidence of his exploitations. The government's investigation revealed that some payments were made by him through attorneys to settle lawsuits filed by individuals who threatened to release information regarding his exploitations, including lawsuits filed by individual B and co-defendant McDavid. Specifically, as the superseding indictment alleges, Kelly made multiple payments to individual B. And then they have between approximately 2001 and approximately 2009, Kelly, McDavid, individual A, and others caused individual B to be paid hundreds of thousands of dollars for obtaining and returning multiple videos that they knew depicted Kelly engaged in contact. And then it says superseding indictment. So who is this? Lisa Van Allen, Damon Pryor, and the Brown. I can't think of his first name, but you guys know who I'm talking about. Then it goes on to say, on or about June 30th, 2009, Kelly and McDavid caused a wire payment to be made from a Bass Production Limited bank account to pay individual B to settle a lawsuit that individual B had filed for payment for recovering and returning tapes that depicted him in them. So, and those are statements from the indictments. Then it goes on to say the government's investigation revealed that this June 30th, 2009 payment was for $125,000 and was facilitated through his former attorney at law firm A. One of the grand jury subpoenas at issue requested records for the relevant time frame associated with the bank account held by law firm A used to make the $125,000 payment, as well as for bank records for the payments to individual B from individual B's attorney. These records, together with the bank records of his business Bass Productions, revealed that Bass Productions wired $125,000 to law firm A, which then wired $125,000 to individual B's attorney, who ultimately made two payments to individual B. Contrary to his claims, this was not a fishing expedition. The grand jury was investigating the source of payments made to individual B, which were part of his obstruction of justice. After it was determined that at least one of these payments were made via an account held by law firm A, it was reasonable for a grand jury subpoena to be issued to a bank seeking records for that account. Bank records received in response to the subpoena have been produced by the government only to counsel of record pursuant to a strict protective order that restricts defense counsel from further dissemination. He cites Section 9-13410 of the U.S. Attorney's Manual, now known as the Justice Manual, for the alleged proposition that the government should have provided notice of the subpoena to law firm A and attorney A discussed below. The Justice Manual provides no such thing. The section cited by him refers to subpoenas sent to an attorney, not to a bank. Indeed, the section expressly excludes a subpoena to a bank for records of an attorney's trust account, because trust accounts tend to hold the pooled funds of numerous clients, and records related to such accounts ordinarily do not relate to individual clients and do not contain or reflect privileged or confidential attorney-client communications. Justice Manual Section 9-13410. It says he also incorrectly contends that the bank records may be protected by the attorney-client privilege. Simply put, in order for the attorney-client privilege to attach, the communication in question must be made 1. in confidence, 2. in connection with the provision of legal services, 3. to an attorney, and 4. in the context of an attorney-client relationship. United States versus BDO Seidman. And that's a case from 2007. And it says here, the bank records sought by the grand jury were transaction records held by third-party financial institutions. Thus, the records are not confidential communications between the attorney and client, and they are not cloaked in the attorney-client privilege. United States versus Miller. There is no legitimate expectation of privacy in the contents of bank records maintained by financial institutions. Alrighty then. So basically they're saying that if they subpoena the bank for your banking records, that the bank is obligated to give them that information. And I think we all know that happens a lot in criminal cases. So in short, and actually not even in criminal cases, because like if you default on your student loan or some other loan, or even look at the payroll protection loans that's in the news today from the coronavirus package, how the government is going into these bank accounts where this money was sent to, and then they're looking at how people are spending this money. So like with student loans, if you default on your student loan, they can subpoena your bank account records and then garnish your bank account, and take your money out of your bank account to pay for your loans. And then with the small business loans, what they're doing is where the money was deposited, they're going in and subpoenaing those records to see what businesses are doing with that money. And that's why you see people being arrested, for going out buying, $50,000 cars, $300,000 cars, paying off mortgages, withdrawing cash and throwing wild parties and stuff. So, they do have, I don't know if the state has that type of authority, but the federal government does. So then it goes on to say, in short, the issuance of the subpoena was not an abuse of the grand jury's powers, and there is no cause to grant the broad relief he now requests. And then it says he demands that this court permit his attorneys to review all grand jury subpoenas, not just the subpoenas allegedly issued in error, and materials produced to the government in response to all grand jury subpoenas. While some grand jury material has been disclosed to the defense in the ordinary course of discovery, The defense is requesting all grand jury material amassed in the course of the investigation, even if the government otherwise would not be required to disclose these materials in discovery. Such relief would be extraordinary and unnecessary under the circumstances. A defendant seeking grand jury materials bears the burden of making a strong showing of particularized need for grand jury materials before disclosure will be allowed. United States versus Sales, which is from 1983, states that because grand jury proceedings are secret and their disclosures limited by Federal Rule of Criminal Procedure, a party seeking grand jury materials under Rule 6E must show that the material they seek is needed to avoid a possible injustice in another judicial proceeding, that the need for disclosure is greater than the need for continued secrecy, and that the request is structured to cover only material as needed. And then they cite another case, Douglas Oil versus Patrol Stops Northwest, and that's from 1979. So it says he has not made that showing as discussed above. The subpoena for the account that held law firm A was reasonably issued in the course of the grand jury's investigation, and to the extent the subpoena resulted in the production of records unrelated to the $125,000 payment for him to individual B, the government has asked counsel of record to return the records, and the government will destroy them as well as all copies in the government's possession. At trial, the government will seek a stipulation related to the $125,000 payment. To the extent a stipulation is not possible, the government will seek only to introduce records from law firm A's bank accounts that are related to the $125,000 payment to individual B described above, and the government does not intend to publicly disclose the identity of law firm A. The fact that the subpoena was a proper use of the grand jury, the government's limited use of bank records related to law firm A, together with its efforts to ensure that unrelated bank records are returned and destroyed, moots the need for any further remedy. And then part 3, it says the government reasonably subpoenaed records related to his assets. The second subpoena at issue, as explained above, relates to his assignment of royalties to individual E, which resulted in the government obtaining certain bank records of attorney A, who represents him in the federal criminal case in New York. This subpoena, too, was proper and reasonably related to the grand jury's investigation. As background, as alleged in the superseding indictment, he has a long history of bribing and attempting to bribe people and witnesses to lie about and conceal his activities. Wealth he earned from his music career allowed him to pay large amounts of money for this purpose. And all of this is alleged, people. In part, to identify these payments, the government subpoenaed records for bank accounts associated with him and his businesses. The subpoenaed records indeed contained evidence of numerous such payments. In 2019, he opened a new bank account in the name of a nominee, individual E, shortly after he was charged with crimes including exploitation in the Circuit Court of Cook County, Illinois. A few weeks after being charged in March 2019, individual E incorporated Some Brother Love LLC. 9 days after that, on April 2nd, 2019, he assigned some of his music royalties to Some Brothers Love, and shortly thereafter, royalty payments for his recordings began to be sent to a bank account in the name of Some Brother Love. The assignment of his royalties to Some Brother Love and individual E does not appear to have been an arm's length transaction. It does not appear that he received consideration in return for assigning his rights to the royalty payments. In addition, in recorded jail calls, he appears to have directed people to contact individual E to receive payments indirectly from him. Accordingly, in the course of its investigation, the government subpoenaed bank records for the aforementioned Some Brother Love account into which royalties for his recordings were being deposited. The bank records would demonstrate how those payments were being dispersed from the Some Brother Love account and whether they were being dispersed to further his interests, including possibly as bribes. It also was reasonable to investigate the assignment as a potential attempt by him to avoid financial consequences associated with criminal charges, including fines and restitution. The subpoenaed records revealed that the Some Brother Love account received deposits of at least approximately $1.2 million in royalty payments for his recordings in 2019. The bank records also show outgoing payments in various forms, with some but not all of the payees identified. To identify the unidentified payees, the government used grand jury subpoenas to trace the payments, including by requesting records for accounts that received bank transfers from the Some Brother Love account during the relevant time frame. The government did not know who held those accounts when it issued the subpoenas. One of the unidentified payees turned out to be Attorney A, an attorney for him. There was nothing improper about the issuance of grand jury subpoenas for bank accounts that received payments from the Some Brother Love account. Contrary to Kelly's argument that the subpoena resulting in the production of Attorney A's bank records to the government was somehow meant to intimidate and harass his attorneys, the government did not know at the time the subpoenas were sent who the account holders were. They were identified payees. It was only when the government received the records from the bank that it learned that one of the unidentified payees was one of his defense attorneys. Indeed, the use of these funds for his expenses and his recorded conversations directing people to contact individual E for funds from him refute assertions in his multiple motions for pretrial release that he has no money. In any event, when defense counsel asked the Attorney A's records be reclaimed from the co-defendants to whom they were produced in the ordinary course of discovery pursuant to a protective order that prohibited their further dissemination, the government promptly did so. Thus, the only parties who currently have those records are him and the government. The government has already sought the return of Attorney A's records from him and will destroy all records that do not show his control of the money in the Some Brothers Love account. It will do the same with all copies of those records in the government's possession. The government will not use any Attorney A's bank records at trial. To the extent the government needs to admit evidence to prove that he maintained control of the money in the Some Brothers Love account, either at trial or sentencing, the government will seek stipulations to avoid having to reference payments to Attorney A. If any filings need to attach such records as exhibits, the government will do so under seal. And then number 4, in conclusion, the bank subpoenas here were issued for legitimate law enforcement reasons in the course of a broad investigation into his acts of obstruction over many years and potential use of a nominee bank account to conceal assets and not to harass or intimidate anyone. His wild accusations and inaccurate speculation as to the government's motives are unfounded and in any event would not support the broad disclosure of all grand jury subpoenas and materials not otherwise discoverable in the criminal case. to the defense. In addition, the government's transparency in producing the records and efforts to limit the use and dissemination of unrelated records moots the need for any additional remedy. His motion, therefore, should be denied. Then signed, respectfully submitted, John Lausch, but we know that it was written by Angel Krull, who is over this case. So let me go back up here because I'm kind of confused as to who. So are they saying individual E is the person that he assigned to the bank account? So we already know he signed his royalties over to a childhood friend. I don't know if it's Keith or not, but it's a childhood friend that he signed his royalties over with so that this person could continue, to pay his child support, could continue to pay his employees, because he still has employees on staff, to continue to pay his rent. I believe, I don't have no proof, just what I believe. I believe he still owns at least one condo in Trump Tower, despite people having to move out and all this other stuff. I believe he owns that Trump Tower condo. And the reason I believe he owns it, one, is because he's lived there so long. Two, because there was a realtor that was interviewed by a newspaper who stated there are no rental units in the condo portion, in the residence portion of Trump Tower, and that his all condos are owned and they don't have rental properties. So that led me to believe that that condo is in somebody else's name and he still owns that condo. Then he has to pay for Joycelyn's expenses because she moved into her own apartment and all that good stuff. He still has to pay for the storage of all his, he still has his tour buses, all of his equipment, his studio equipment. And so whoever he assigned these royalties to, I'm sure the defense will be able to come back and show receipts of how all of this money was being spent. And then for them to act surprised that he received $1.2 million in royalties last year, to me is just crazy, because remember, they say that he has a tax liability, that his 2019 taxes, which is actually from income that was earned in 2018, was like $1.4 million or something like that. It was like over $1 million. Okay, so to have a tax liability for that much money in 1 year meant that he had to have made at least $3 or $4 million in 2018. So they're trying to act like, oh, he's hiding his money. He's pretending like he doesn't have any money, which is stupid because he obviously files his taxes. Okay, so he was trying to hide money. He wouldn't be filing his income taxes. And so it doesn't sound like they really found what they were looking for. What do you guys think? I just see, because it seemed like they would have put some more stuff in here. And then I don't understand how they want to keep from the defense all this stuff, because say you're in trial and they come up and say, okay, well, we got this check here for $1 million that he paid so-and-so. What do you do with that in the middle of the trial? Like, how do you allow them to produce that as evidence and then you're not prepared to respond to that? So this whole thing with playing with discovery and all this stuff, it makes absolutely no sense to me. But anyway, that's their response about the banking information. Another petty response where they're basically trying to make Greenberg look stupid, like he doesn't know the law, and maybe he doesn't know federal law that well. Maybe some of these motions he be filing pertains to state laws and they're a little different than federal laws. I don't know. The Mike Leonard guy seems to get a better response, a more professional response, to the motions that he files. And when Greenberg files motions, we get this petty back and forth going on. But anyway, I'm going to end this here, guys. Leave your comments below. Let me know what you think. Rate the video and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye bye.